I listened because he was a very, very good attorney. I listened because I am familiar with his personal narrative. And while he was talking, I scribbled down, of course he's right. You have a right to remain silent. You also have a right to confront your witnesses. That right is in the exact same document that the right to remain silent is in. You have a right to cross-examine witnesses, Mr. Chairman, and I think it's important for us to spend just a minute on why our framers thought it was so important that you be able to confront and cross-examine witnesses, because it is the single best way to elicit the truth. Yes, you have a right to remain silent. You also have a right to a jury trial, but it's waived every day across this country. When you plead guilty, that is a waiver of your right to a jury trial. You have a right to counsel in felony cases. People waive it all the time and make the mistake of representing themselves. So when we're going to talk about rights, let's talk about all the rights, including the right to confront witnesses and cross-examine witnesses, Mr. Chairman. And it's important that we understand why we were given those rights. Ms. Lerner is an attorney. She's not like the folks that Mr. Cummings represented or the folks that I prosecuted. She's an attorney, and she had an attorney sitting behind her. And some of my colleagues on the other side this morning, Mr. Chairman, and you heard them, they said we need another hearing where we can bring in experts. Well, let me take out all the drama from what that hearing would be like. We would pick 3 that said she waived, and they would pick 1 that said she didn't. Okay? I hate to do a spoiler, but that's the way that hearing would go. We would find 3 that said she waived, and you would find 1 that said she didn't. So we'd be right back where we are now, which is us having to make the decision. Or, Mr. Chairman, we can go to the language of the Supreme Court, which is kind of the ultimate expert. I would argue it is well established that a witness in a single proceeding may not testify voluntarily about a subject and then invoke the privilege against self-incrimination when questioned about the details. And the Supreme Court continued, in such a case, the privilege is waived for the matters to which the witness testifies, and the scope of the waiver is determined by the scope of the relevant cross-examination. What that says, Mr. Chairman, is you do have a right to remain silent. But when you talk, not some talismanic recitation of words which they're saying you should have done, some rote liturgy that you have to repeat to a lawyer who knows her Fifth Amendment right as well as you do. But when you waive by testifying, you subject yourself to cross-examination. And that is true for every client that Mr. Cummings had. It is true for every sexual assault victim that I had to call as a witness. They couldn't give their version of what happened and then not stand for cross-examination. That's not the way the system is set up. And it's not set up that way because the purpose is to elicit the truth. So, Mr. Chairman, I'm going to simply ask this. This is what she said when she came before our committee. 17 separate factual assertions. If this is not testimony, can someone on the other side of the aisle please tell me what is? Does it have to be 20 factual assertions? 25? What constitutes testimony to you? If what she said and the pervasiveness of her testimony, 17 separate factual assertions, if that is not testimony, then tell me what is. And if that's not waiver, then tell me what is. Mr. Chairman, there have been a lot of conversations about rights. Most of the conversations have been about Ms. Lerner's rights. But that same document gives you the right to free speech and the right to petition your government for redress. And while Ms. Lerner may have waived her right, our fellow citizens did not. And the only way we're going to find out what happened is if she answers our questions. Not just says, I did nothing wrong, but answer the questions that all of you agree are legitimate questions. If this isn't waiver, tell me what is. And if that wasn't testimony, then please explain to me what would constitute it in your mind.
Gentleman yields back. Utah, Mr. Chaffetz.
I thank the gentleman. I'd like to yield to the gentleman from South Carolina, Mr. Gowdy.
I thank the gentleman from Utah. Mr. Chairman, you have an absolute right to remain silent. No inference or suggestion of guilt may be inferred from your invocation of that right to remain silent. However, if you do testify or take the stand, you will be treated like any other witness and subject to cross-examination. Mr. Chairman, the reason that phrase is running through my mind is because I heard it for 16 years. It's being repeated in courtrooms all across this country today, but not for powerful people that work for government, just for everyday folks. Just for everyday witnesses or everyday defendants of petty crimes, not charged with violation of constitutional rights, maybe just petty larceny. But they're being told you have a right to remain silent. However, if you testify or take the stand, you will be treated like every other witness. Mr. Chairman, I counted 17 separate factual assertions by Ms. Lerner, not those 3 little sentences that my colleagues like to cite, 17 separate factual assertions. That is a lot of talking for somebody who wants to remain silent. That's a lot of talking. If you honestly believe that you can make 17 separate factual assertions and still invoke your right to remain silent, then please tell me what waiver is. Please tell me what constitutes waiver if saying 17 separate factual things does not. Mr. Chairman, she testified, I have done nothing wrong, I've broken no laws, I've broken no IRS rules or regulations. That's her testimony. What I'm saying is we should have the right to cross-examine her on that testimony. Because I'd like to ask her, when you said we need a plan, who is we, and what plan are you referring to? When she said we need to be careful that it's not perceived as political, who is we, and what are you concerned about the perception of politics for? What are you fearful of, Ms. Lerner? She said, I think we really need to do a project. Again, Ms. Lerner, who is we, and what project are you referring to? That is a legitimate question. And every brother and sister at the bar on the other side of the aisle would ask that question on cross-examination if given the opportunity. Can you imagine, Mr. Chairman, can you imagine a fact pattern where somebody takes the stand and says, I didn't rob the bank, but I'm not going to answer why my fingerprints are on the demand note, and I'm not going to tell you why I'm on the surveillance footage with the gun in my hand, and I'm not going to tell you why the dye pack blew up in my car. I'm just going to tell you I didn't rob the bank. That's not the way our system works. You have to answer the other side's questions. I think these questions are fair. The Tea Party's very dangerous. Dangerous to whom? Who, Ms. Lerner? Who thinks they're dangerous? You? The IRS? Dangerous in what way? We need a vehicle to get back to court. Who is we? Why do you want to get back to court? Could it, heaven forbid, be because you don't like Citizens United? Is that possibly the explanation? Mr. Chairman, she said Cincinnati should not have these cases, but then she turned around and said Cincinnati was to blame. That's an inconsistent statement. Every lawyer on that side of the aisle would ask her to explain that inconsistency. Everyone. So why can't we? If this isn't waiver, then can someone explain to me on the other side what fact pattern constitutes waiver? If you can make 17 separate factual assertions and authenticate a document, and say, I have done nothing wrong, which is about as broad as any testimony can possibly get. I've done nothing wrong. I've broken no laws. I've broken no rules or regulations. I mean, honestly, what testimony could be broader than that? So necessarily, our cross-examination should be equally broad, and it would be in a courtroom. How often did you use your personal email, Ms. Lerner? That's a fair question. The Committee on Ways and Means just referred that issue to the Department of Justice. How many times did you use your personal email? When you mused about applying for a job with an organization connected with the president, were you kidding, Ms. Lerner? Or were you serious? Oh, we know you were contemplating retirement. Were you really seriously going to work? Mr. Chairman, I know my time is up. I'm just going to say this in conclusion. The same Constitution that allows her the right, if she wants to sit there and say nothing, allows these groups the right to petition their government for redress.
I appreciate the gentleman. The gentleman's time has expired. Who seeks recognition?